Judgment in the matter of Nottingham City Council versus Parr and another.
Lord Lloyd-Jones will explain the decision of the court.
This appeal concerns the licensing of houses in multiple occupation, HMOs, by local housing authorities under the Housing Act 2004. It raises in particular the questions whether it is permissible for the authority to have regard to the proposed mode of occupation when considering the suitability of accommodation in an HMO, and whether it is permissible to impose conditions to limit the class of persons for whom an HMO is suitable. Two properties in Nottingham, 44 Rothsay Avenue and 50 Bute Avenue, are houses in multiple occupation and accordingly subject to the licensing regime. The relevant licensing authority is Nottingham City Council. The Council may grant a licence under the Act if it's satisfied that, among other requirements, the house is reasonably suitable for occupation by not more than the maximum number of households or persons specified in the application or decided by the authority, or that it can be made so suitable by the imposition of conditions. The appellant also issues guidance on the operation of the licensing system. This guidance provides that the minimum space provision in the case of bedrooms in single occupation in HMOs is 8 square metres, although a degree of flexibility is sometimes possible if other features are present. The two properties are used for letting to students, and each has an attic bedroom with an area of usable living space below 8 square metres. In each case, the appellant granted an HMO licence which imposed a condition prohibiting the use of the attic bedroom for sleeping. The respondents appealed successfully to the first-tier tribunal against the imposition of the conditions. In the case of 44 Rothsay Avenue, the tribunal substituted a condition that the attic bedroom may only be used for sleeping accommodation by a full-time student who resides in the bedroom for a maximum of 10 months in each year. The appellant appealed both decisions to the upper tribunal, which dismissed the appeals and directed that the substituted condition also be included in the licence for 50 Bute Avenue. The appellant then appealed to the Court of Appeal, which upheld the decision of the upper tribunal and included further conditions in both licences that the communal space be kept available for communal living only and that no bedrooms be let to persons other than full-time students. The appellant now appeals to the Supreme Court, which unanimously dismisses the appeal. The 2004 Act indicates that the purpose of the imposition of conditions is to make a house reasonably suitable for occupation by not more than the maximum number of households or persons specified. It provides that a licence may include such conditions as the local housing authority considers appropriate for regulating all or any of the management, use and occupation of the house concerned, and it sets out a non-exhaustive list of permitted conditions, including conditions imposing restrictions or prohibitions on the use or occupation of particular parts of the house by persons occupying it. These words, in their natural meaning, permit the conditions imposed by the tribunals and the Court of Appeal. Such a reading is also consistent with the object and purpose of the 2004 Act. Elsewhere in Part 2 of the Act, the manner of occupation and characteristics of occupants are considered relevant in contexts connected with HMOs and housing standards generally. As a matter of common sense, the manner of occupation of a room and the type of occupant may have a bearing on the suitability of a particular room for a particular use. The Court does not consider that the conditions in issue introduce an exception for a category of persons or a defined set of circumstances. It is therefore appropriate to have regard to the proposed mode of occupation in considering the suitability of accommodation in an HMO. In particular, account should be taken of the proposed mode of occupation where it is likely to influence the quality of the accommodation made available to the occupant. However, this does not permit the application of lower standards than would otherwise be applicable. Thus, the power to impose conditions under the Act can be used to limit the class of persons for whom the HMO is suitable. The Court observes that it is clear that the appellant, in bringing this appeal, and the Secretary of State, in intervening, have been motivated by a wish to ensure that HMOs provide acceptable living conditions, to protect the vulnerable or potentially vulnerable groups that tend to occupy HMOs, and to avoid an interpretation of the legislation as a result of which lower standards are to be considered appropriate for particular groups, such as students. In the judgment, the Court explains why it considers these concerns to be unfounded. The Court considers that the conditions imposed are, with one exception, both rational and enforceable. The exception is the requirement limiting occupation to 10 months in each year, which in the Court's view is irrational. Accordingly, the Supreme Court varies the conditions to delete the requirement of occupation for a maximum of 10 months in each year, but otherwise dismisses the appeal.